a potential setback for cops throughout the Southland in their battles against gangs. A federal court has ruled that in one crackdown, the Orange County DA violated suspected gang members' civil rights. David Nazar, what's the story?
Rick, for years, law enforcement authorities have been fighting gangs with injunctions, controlling where gang members can gather, what they can do, even what they can wear. Well, dozens of gang injunctions are in place in LA County, for example, and about a dozen in Orange County. In 2009, Orange County District Attorney Tony Rackauckus and the City of Orange Police Department filed an injunction against more than 100 people suspected of belonging to the Orange Barrio Cypress gang. Well, when about half those folks showed up in court claiming they were not gang members, the DA simply dismissed them from the case. A legal maneuver that still enabled Rackauckus to get the injunction against the gang itself and then to again target the 50 or so people who had been dismissed. That's when the ACLU stepped in, claiming those suspects had been denied due process. Now a federal appeals court has agreed. It is a decision that could impact the way law enforcement targets gangs throughout the region and could cost Orange County taxpayers more than $3 million. For years, the ACLU questioned the manner in which District Attorney Tony Rackauckus and local law enforcement agencies imposed gang injunctions. They've used nuisance abatement orders to rid neighborhoods of gang activity. The DA would use the orders to target a neighborhood with gang members and prevent them from engaging in certain activities, both legal and illegal. For instance, no violence, drug use, or intimidation, or it can be as simple as not wearing certain colors, associating with certain people, or being out past certain hours. This is a common practice by prosecutors that's been in use in California since the 1980s. The ACLU spent almost $3.5 million on behalf of the accused gang members, fighting Rackauckus and the City of Orange in court, claiming the injunctions violated their right to due process.
At its very base, fundamental level, this is a constitutional issue. If I'm accused of committing a crime, if I'm accused even of murder, the Constitution gives me the right to go to court and defend myself and say, I didn't do it if I didn't do it. There's no reason it should be any different with being accused of being in a gang.
The Orange County DA's office, in good faith, filed these lawsuits, and we're following the procedures that we believe were in place and were constitutional. We respectfully disagree with the court's ruling, and we feel it's unfortunate that basically the only thing that this court ruling did was line the pockets of folks who defend gang member rights with the tune of $3.2 million of taxpayer money, and we think that's extremely unfortunate.
The DA's office has been defiant of the appeals court ruling. Since the case, it has implemented 6 more gang injunctions in 4 different cities throughout Orange County, citing the method as a tremendous crime deterrent.
We believe that gang injunctions are one of the most effective ways to go after gangs and to keep the quality of life for those folks who have to suffer from these gangs in those neighborhoods.
Why do you believe they're so effective?
The proof is in the numbers. When you have these gang injunctions, the violent crime rate goes down dramatically. The call for services, people who feel empowered to call the police, they go up, and the statistics are there.
In theory, are gang injunctions a good thing?
They certainly deprive people of their liberty. They're deeply intrusive into people's liberties. But when trying to fight crime, you can't cast such a wide net that you don't give innocent people the chance to prove that they're innocent.
There are crime stats across Southern California that do show that crime does decrease with these gang injunctions.
I don't necessarily doubt those numbers. That may be accurate. Of course, you could see crime decrease through any number of draconian, unconstitutional measures. The question is, how do they go about doing it?
Are you defending gang members who, quite frankly, don't deserve defending?
Far from it. First of all, everybody has the right to be defended. That's a fundamental principle of our court system. But more than that, we're defending the people who want to say that they're not in the gang, that the DA got it wrong, that the DA can't sit up on high and say you're in a gang and that be the end of it. We're defending the folks that want to be able to say, I'm trying to find a way out. I live in this neighborhood where the gangs are, but I'm not in the gang. And we're defending those folks.
And Rick, you heard right. The ACLU is due $3.2 million. Now the question is, of course, exactly who's on the hook? The county, the City of Orange, or both? Well, I put calls into OC supervisors Todd Spitzer and Sean Nelson and they aren't responding to this issue, although the city attorney for Orange, Wayne Winters, told me it's unknown exactly what the split could be between the county and city. It could be 50-50. Of course, they're looking into it, Rick.
You know, David, I understand the ACLU's argument on this, and I have to agree with them that, you know, people are entitled to due process, even if it means it's a little harder to combat crime. But $3 million, you got to give me a break. I just don't buy that the ACLU actually spent that much money on this case.
Well, look, hold on. That's what the ACLU was saying. Remember, the court case was only about 2 weeks, but this began back in 2009. So they're talking a few years of legal fees, experts, witnesses. That all added up, and in the final analysis, they said, yeah, it was $3.2 million, and the judge ruled that those were the bills that are now due the ACLU.
Yes. Okay. Well, I just don't buy it, David. Okay. But you know, how will this really hurt the attempts by law enforcement to control gang activity?
Well, remember, it's not necessarily the gang injunction. As Susan Schroeder, who you saw in the story, explained to me, it was almost a technicality. It was the way it was carried out, that these folks that were suspected, alleged gang members, they were not sort of given their day in court, their due process. So it's the injunction that's really not unconstitutional. I suppose it's the way you carry it out. And whether it's defiance or whether the OCDA believes this is really the best way to fight gangs, they say they're going guns a-blazing, they're not going to stop. And when I do talk to some of the neighbors in the streets out there, whether it's Anaheim or Garden Grove or these stories I've covered, not to defend the DA's office, but the neighbors do sometimes say, we feel a bit safer knowing there are injunctions and gang members aren't walking the streets. That's what I hear.
Yeah, and I think practically speaking, I mean, you know, I'm not. We'll have to hear from criminologists and those folks and see, you know, what they say. But it seems to me that this could be really tough now, because in the past, you want to crack down on a gang, you round up a few of the usual suspects, some hardcore gang members, you get the injunction, then you can start cracking down on everybody. Now cop stops them, they say, hey man, I'm not part of this gang. You're going to have to take that person into court. I could see this really being tough on law enforcement. Anyway, David, thanks very much.